Welcome back to the deep dive. We are continuing our journey through the Manual of Patent Examining Procedure, the MPEP.
Yep, still working through it.
And this series, as you know, if you've been following along, is all about making sense of these, let's be honest, sometimes dense patent rules. We want to give you clear, accessible explanations.
So you can see how each piece fits into the bigger picture of U.S. patent practice.
Exactly. And we should definitely give a shout out here.
Oh, absolutely. To Mike Shepard. He's the creative director for this whole audio series. And, well, his vision is really what's making these detailed MPEP summaries possible in this format.
Couldn't do it without him. Okay, so today we're diving into a really specific high-stakes area, MPEP Chapter 1400, Correction of Patents.
And within that, we're hitting MPEP Section 1404. This one is all about submitting papers when a reissue patent application is happening.
While the patent itself is being fought over in court.
Right. Precisely. Active litigation.
So how do you handle the paperwork with the USPTO in that specific scenario? Okay, let's just paint that picture for a second. This isn't just like routine filing.
Got it.
You've got a patent owner trying to fix an error in their patent at the USPTO, that's the reissue part. And at the same time, that exact patent might be central to a huge infringement lawsuit somewhere else. Talk about pressure.
That's a perfect way to put it, a chaotic nexus. And really, the whole point of MPP Section 1404 is to bring some mandatory order, some visibility to that chaos.
Okay.
Because when a patent's validity is being questioned in two places at once, federal court and the USPTO, the patent office side of things, needs to move, well, faster and more predictably.
So the core mission here is identification, making sure these papers scream urgent, pay attention.
Exactly. Clear identification so they get the heightened special attention they absolutely need.
The stakes just feel massive. I mean, if the USPTO looks at the corrected patent during reissue and says, yeah, this is valid, that's huge leverage for the patent owner in court.
Wow, enormous leverage.
Yep.
But flip side.
If the USPTO says, no, these claims aren't patentable even after correction.
That could completely sink the litigation for the patent owner. It's critical.
So given those stakes, what does the MPP actually demand? What are the physical steps someone has to take to flag this urgency? Applicants or even, say, third parties?
Right. It applies to both. And the MPP is very, very specific here. It mandates dual markings. You must clearly label the submission with the exact words, reissue litigation, no variations.
Reissue litigation. Got it. And where does that label need to go?
Two spots. Critically. First, it has to be clear on the outside of the envelope or the package.
Yeah.
So the mailroom sees it immediately. This isn't just regular mail.
Okay, makes sense.
And the second place.
And this is key for internal processing.
Yep.
It has to be on the top right-hand portion of the actual papers inside the envelope.
Right of the documents themselves.
Yep. That way, even after it's open, scanned, docketed, whoever picks up that file instantly knows, this is tied to an active court case. I get the urgency marking. I really do. But let me push back a little. In this day and age, everything's electronic, right? Why rely on physical markings? Couldn't you just, check a box in EFS Web or something? Why these physical labels that, let's face it, someone could forget or miss?
That's a really good point. And it touches on administrative control and, frankly, redundancy. Yes, electronic filing is standard, but think of the physical marking as a critical failsafe. It's a visual cue for immediate physical handling and routing once it's inside the office.
A failsafe. Okay.
And if you mess up,
yeah,
if you forget that marking, the risk is huge. Your paper might just get filed, docketed, and sit in the regular queue.
Treated like routine mail.
Exactly. Which could mean delays of weeks, maybe months. Now imagine you're in litigation. Maybe you've asked the judge to pause the court case pending the USPTO's review of the reissue.
A delay like that could be disastrous.
It could be fatal to your legal strategy. It totally undermines the whole point of trying to get that expedited administrative review during litigation.
So failing to comply isn't necessarily like getting your paper rejected outright, but it could lead to catastrophic delay, which is basically a massive strategic blunder for the lawyer involved.
Precisely. You lose that crucial benefit of priority processing. It just becomes another piece of paper in the pile.
Okay. Now, speaking of priority, you said the MP demands more than just the reissue litigation tag. It also requires specific targeted routing information. It's not just urgent, it's urgent, send it here.
Correct. You need to tell the USPTO exactly which internal group needs to see it.
So what kind of internal destinations are we talking about? What dictates where it goes?
This is where it gets a bit technical, but it's vital for efficiency.
Yeah.
The marking has to point to the specific office or art unit handling the reissue application itself.
Wow.
So, for example, it might need to go broadly to the Commissioner for Patents.
When would that happen?
Usually if it's about, say, a major policy issue or maybe a petition decision that affects things across different parts of the office.
Okay. But what if the patent is also being challenged within the USPTO? Like at the Patent Trial and Appeal Board? The IPR, maybe?
Great question. Yes, absolutely. If there's a parallel PTA proceeding, like an IPR or a post-grant review on the same patent, then the papers absolutely must indicate the PT day as the destination.
Because the office needs to coordinate those.
Exactly. They need visibility across related proceedings.
Hmm.
Or, alternatively, if it's a really tricky point of law or rule interpretation, it might need to go to the Office of Patent Legal Administration, OPLA.
Huh. So it's not just slapping an urgent sticker on it. It's like you're providing the internal UPS tracking label for the USPTO mail system.
Yeah.
You're making sure it lands on the right desk, the one that can actually do something about it quickly.
That's a perfect analogy. Following these specific routing procedures is how the office rapidly connects the submission to the right internal file and understands its connection to the external court case. It guarantees the matter gets handled with the proper urgency and administrative attention.
Right, which avoids wasting the court's time while they wait for the USPTO to sort something out that's stuck in the wrong queue.
You got it. Judicial resources aren't wasted.
Okay, let's talk payoff then. The MPEP explicitly says papers marked reissue litigation get special attention. We know that means avoiding delays, but what does special attention actually mean inside the USPTO? For the examiner, for their boss, does it just literally sit on top of the pile?
It's a bit more structured than just, landing on top. Think of special attention, less like a vague promise and more like an internal directive for expedited processing.
Okay.
So it means prioritized docketing. The case likely gets assigned very quickly, often directly to a supervisory patent examiner, an SPE.
Someone with more experience.
Usually, yes. Someone who's handled these complex litigation-entangled files before. And importantly, they often face tighter internal deadlines for taking action, like issuing office actions.
Ah, okay. So for the patent owner in court, this faster USPTO process isn't just convenient, it's actually part of their strategy with the judge, isn't it? They're essentially saying, Your Honor, look, we see the potential issue, we're fixing it right now, quickly at the USPTO. Can you hold off on ruling until they're done?
Exactly right. It can be a powerful defensive tool. It allows the patent owner to try and quickly fix any alleged problems that the other side in the lawsuit has pointed out.
And if they succeed, if the claims get corrected and reissued,
then they can take those potentially stronger corrected claims back to the judge. That could significantly bolster their case, maybe lead to a better settlement, or even change the outcome entirely.
That actually brings up a more fundamental question for me. If the courts are already deciding if the patent is valid or infringed, why even go through the whole reissue process at the USPTO? Isn't it kind of redundant, costly, maybe even confusing?
That really gets to the heart of the tension here. The USPTO and the federal courts, they have overlapping jurisdictions in some ways, but their roles are distinct.
Oh.
Well, the court is primarily looking at infringement and validity based on the patent as it currently exists. The USPTO, through reissue, offers the patent owner a chance to change the patent, to correct genuine errors made during the original application process.
Like what kind of errors?
Maybe the claims were drafted too narrowly by mistake. Or perhaps there was an inaccuracy in the specification, the written description. Reissue is fundamentally a mechanism for self-correction, allowed under specific rules.
Okay.
And doing this quickly, under this special attention rule, lets the owner try to present the court with the best, cleanest version of their patent possible, hopefully reducing their legal risk.
Yeah, that makes sense. It's about fixing it proactively. Which leads us to another balancing act the USPTO has to manage: transparency versus efficiency. We know the whole reissue file is public record, right? The filing even gets announced in the official gazette.
That's correct. Transparency is high.
Yet this section and the related regulation 37 CFR 1.291C sharply limits who else can jump into the process. Specifically, protesters. What are those limits? What can and can't a third-party protester do here?
The limits are quite strict, actually, and they're really designed to stop the USPTO reissue process from turning into a second parallel litigation battlefield.
Right, keep it focused.
Exactly. So while the system is transparent, anyone can look at the file participation is curtailed. A protester can submit certain things, primarily prior art, Documents or patents that might show the invention wasn't new or was obvious. That information is helpful to the examiner.
So they can provide evidence relevant to whether the claim should be allowed.
Yes, evidence related to patentability, like prior art references. But that's pretty much it.
What can't they do?
Beyond submitting that kind of relevant prior art or maybe related publications, protesters are explicitly blocked from acting like a party in the litigation. They can't file arguments about the merits of the corrected claims. They can't respond to the examiner's office actions. They can't demand interviews. They're basically shut out from active participation.
What's the worry there? If it's all public anyway, why not let other interested parties weigh in more fully?
The primary concerns are potential misuse and intentional delay. If the opposing party from the lawsuit could fully intervene in the reissue,
I see.
they could potentially use the USPTO process just to harass the patent owner, maybe force them to reveal litigation strategies prematurely through filings, or simply bog down the administrative process with endless arguments. It could stall everything.
Turning the USPTO into a discovery tool or a delay tactic for the court case.
Precisely. So, by limiting protesters mainly to submitting relevant prior art, the USPTO gets the benefit of potentially useful public input, the key evidence, but keeps the reissue examination focused, orderly, and crucially expedited, which is the whole point when there's parallel litigation.
It really is a fine line they're walking, trying to keep the administrative process clean while still acknowledging the massive legal fight happening outside the USPTO walls over the same patent.
It aims to ensure the USPTO can do its job, which is examining the patent correction efficiently without getting sucked into being a proxy war for the court battle.
Okay, so wrapping up the core procedural lesson from MPP section 1404, it seems crystal clear that when you're in this tricky spot where patent reissue meets court litigation, meticulous labeling is absolutely key.
Non-negotiable.
You have to use reissue litigation both on the outside envelope and on the papers themselves, top right. And you've got to specify the correct internal destination, PTT, commissioner, OPLA, wherever it needs to go. That's how you ensure the application gets bumped up the queue and receives that vital special attention.
And that brings us to the final thought for you, the listener, to chew on. We've established the system values transparency. The whole reissue file is open, announced publicly.
Right.
But then, Section 1404, and the underlying regulation puts a strict limit on public interaction by restricting what third-party protesters can actually submit, basically, just prior art.
The tension we discussed.
Exactly. So here's the question. If the patent system aims for both transparency and accuracy, how effectively does this rule limiting protesters manage that balance? How well does it weigh the public's right to know and contribute information against the very real need for a fast, focused examination when a patent's fate is simultaneously being argued, potentially for millions of dollars, in federal court?
It's a procedural rule with some pretty profound real-world legal consequences. Definitely something to think about.
It really is.
And on that note, our standard but crucial reminder. This deep dive was put together using AI tools like ChatGPT and Notebook LM. It's meant for general educational and informational purposes. This is absolutely not legal advice, nor is it a substitute for proper instruction.
Please don't rely on this for making actual legal decisions.
For any authoritative guidance on patent law or procedure, you absolutely must consult the official MPEP itself or speak with a qualified registered patent practitioner.
Until the next deep dive.